Professor Gary Bourne here as a speaker, along with today's moderator, Dr. Edgardo Muñoz. We really want to thank Edgardo for all his help in coordinating this event and Professor Gary Bourne for accepting the invitation. I will briefly introduce Edgardo and then he will introduce Professor Bourne, even though no introduction is needed. Dr. Eduardo Muñoz is Professor of Law at Universidad Panamericana, Guadalajara, and has been acting independently as counsel, chairman of arbitral tribunals and sole arbitrators in numerous domestic and international arbitrations under the rules of the most prominent arbitral institution of Mexico, United States, and Europe. He is member of the CIS Council since Advisory Council since 2020 and regularly publishes books and journal articles in the field of international business law, the law of obligations, comparative law, sports law, and arbitration. Without further ado, the floor is yours, Edgardo. Thank you very much.
Thank you very much, Andrea. First of all, thank you to everyone who is joining us from different parts of the world. It is a privilege to have as guest speaker, Professor Gary Bourne, talking about a very interesting topic. What I will do now, I'm going to introduce someone that doesn't need really a presentation, an introduction. But reading through his short bio, I found out that there are still many interesting things we perhaps didn't know about Gary. So I will do that, and after introducing Gary, I will say a few words of how this webinar will develop. So Gary Bourne is chair of the International Arbitration Practice Group at Bilmer Coulter Pickering Hale Dorr LLP, and he's one of the world's preeminent authorities on international commercial arbitration and international litigation. He served as counsel in over 675 arbitrations, including several of the largest arbitration in ICC and ad hoc history. And he has sat as arbitrator in more than 250 arbitrations, both institutional and ad hoc. Gary Bourne has published a number of leading works on international arbitration, international litigation, and other forms of dispute resolution. He is the author of International Commercial Arbitration, now in the 3rd edition by Kluge, 2020, the leading treatise in this field, which has received different awards. Among them, the American Society of International Law Certificate of Merit for High Technical Craftsmanship, and the O.J. Meads Book of the Year 2009. He's an honorary professor of law of the University of St. Gallen, Switzerland, Tsinghua University, Beijing, and teaches regularly, basically around the world. Professor Bourne is president of the Singapore Arbitration Center, the SIAC Court of Arbitration, a member of the advisory board of the Hong Kong International Center of Arbitration, a member of the International Arbitration Committee of the Korean Commercial Arbitration Board. Among many accolades, Professor Bourne has received the Global Arbitration Review Inaugural Advocate of the Year Award, the Client Choice Award for Best International Arbitration Practitioner, and the Best Lawyer, London Arbitration Lawyer of the Year. He's one of the only 2 practitioners in London and globally to achieve star status for international arbitration in Chambers Guides. People has described Professor Bourne as an outstanding contribution to the profession and as a one in his own class. So the topic that join us today here has been already discussed in different forums, in particular at the Kluge Arbitration blog, where Professor Bourne has expressed his view about the provisions and likely consequences of implementing the Convention on Choice of Court Agreements enacted in 2005 by the Hague Conference, and compared them with the system in place under the New York Convention on the Recognition and Enforcement of Arbitral Awards. Kanako Arbitration took note of the social media reaction and interactions created by Professor Gary Bourne's post on the topic, and decided to invite him to further express his assessment of this international instrument in this webinar. Mexico, Singapore, the European Union, the UK are among the contracting states of the Hague Convention on Choice of Court Agreements, which highlights the importance of having a public dialogue about the functioning, expected results, and possible drawbacks when applying this treaty for international trade and businesses. So thank you very much, Professor Bourne, for accepting our invitation, and also thanks to all the people who is attending this webinar. Before I give the floor to Professor Bourne, I would like to talk about the agenda for this webinar. Professor Bourne will make his presentation for about 40 minutes. During that time, all participants are invited to pose their questions in writing using the chat function of Zoom. I will take care of organizing the questions in the chat, and after Professor Bourne's presentation, I will read them during a Q&A time of some 20 minutes. So without further ado, Professor Bourne, you are very welcome here at the Zoom platform of Canaco, Mexico. The floor is yours.
Thank you so much. And let me begin by thanking Edgardo and Andrea in particular for both the invitation and opportunity to speak with them on the one hand, but more importantly, perhaps with all of you, their guests, this afternoon, this morning, as the case may be. It's a real privilege and an honor to be able to address you about what Edgardo rightly describes as an important issue. We have a slide presentation that can accompany my remarks, but perhaps before I begin, let me emphasize that as a general matter, I like treaties. I like international agreements between states because they can enhance cooperation. And I think perhaps when you hear my presentation, once we have the slides running, it may be useful to recall those observations on my part. International law plays a fundamentally important role, I believe, in today's society, particularly for commercial matters. And the effective operation of international commerce, trade, and investment has depended in significant part on treaties on international agreements. That said, not all treaties are good things. We know that from history in Europe and elsewhere. And I think it's important that we therefore consider carefully the terms and actual operation of the Hague Convention on Choice of Court Agreements. And as you'll see from my remarks, perhaps we can move along in the slides now. The basic subject of this presentation, like the Kluwer blogs, which Edgardo referred to, is that it's perhaps time to reconsider the convention in countries that have not ratified it, most countries in Latin America, North America, but also in those few countries that have ratified it, including Mexico. And I think that's why the invitation that Edgardo and Andrea extended to me is particularly appropriate, given Mexico's role as one of the first ratifying parties of the convention. We should have no doubt that what I'll call the convention, or the Choice of Court Agreement Convention, has the potential to be very important. It has the potential to fundamentally affect the way that international litigation is conducted, fundamentally alter the terms on which choice of court agreements are given effect, and importantly, the terms on which the judgments that result from those choice of court agreements are recognized and enforced. I think that the rethinking of the convention, the reconsideration of the Convention is also particularly timely because there's been surprisingly virtually no debate and certainly, I think, no critical assessment of the convention, comparing it to past conventions that the Hague Conference has proposed, whether unsuccessful or successful, and also comparing it to the New York Convention. And we shouldn't forget the Inter-American Convention in Latin America, in the Americas. It's especially important to consider the terms of the New York Convention and in parallel the Inter-American Convention, because the drafters of the Hague Convention and its many, I think, quite eager promoters, if I can put it that way, said on multiple occasions, including in the explanatory report to the convention, that they wished to parallel the New York Convention, both in terms of its success. We know the New York Convention has nearly 170 ratifying states, contracting parties, and has been called the global constitution for international commercial arbitration, but also in its basic structure. And we'll come on to this in a few moments, but the New York Convention being essentially a global international agreement accepted by states all around the world, whether in Latin America, in the Americas more generally, in Europe, Asia, Africa, and elsewhere. Like the New York Convention, the Hague Convention aspires to provide for the presumptive validity and enforceability of choice of court agreements, as in contrast to international arbitration agreements, and of the resulting national court judgments that come from litigations that are conducted pursuant to those agreements, just as the New York and Inter-American Conventions provide for the presumptive recognition and enforceability of arbitral awards. Moving on to the next slide, the convention's structure and terms, I'll suggest today, and I suggested in my Kluwer blogs, require a critical, perhaps even a skeptical assessment because of how they deal with the essential questions of party consent, relatedly, therefore, party autonomy, and also the procedural integrity of the adjudicative process. The New York Convention addresses quite carefully both of those two topics, consent and autonomy, procedural integrity, in both its provisions, Article 2 on arbitration agreements and Article 5 on arbitral awards. Unfortunately, the Hague Convention fails, in my view, to provide adequate safeguards for those two, I would suggest, absolutely essential fundamental aspects of international litigation, of adjudication. Questions of consent to a particular forum on the one hand, questions of the integrity, the fairness, the regularity as a procedural matter of the adjudication process. And as a consequence, and I recognize that this is a harsh judgment, in my view, the Hague Choice of Court Agreement Convention poses not a benefit, provides not a benefit or a foundation for international trade and commerce, but instead what would ultimately be a serious threat, and does not advance the rule of law, the rule of international law. Instead has the distinct potential of undermining and contradicting the rule of law. And as a consequence, although it's my personal view, of course, I think states ought not ratify the convention. United States, China, other countries around the world ought not to ratify it. And those states which already have should, as in the case of Mexico, denounce it because it does not advance and instead, I think, undermines both international trade and international law. Let's see why now exactly I believe that. Let's start briefly with some history. The Hague Conference, we're familiar with that on private international law, has proposed a significant number, more than 50, I think, different private international law treaties. A number of those have not gone very far, particularly in the context of judgments. And specifically with respect to judgments, you can see the details on the slide. The Hague Conference struggled for more than basically a decade in the 1990s to agree upon a text of a multilateral recognition of judgments and jurisdiction convention, a so-called mixed convention that would have addressed all aspects of judicial jurisdiction on the one hand, recognition and enforcement of judgments on the other hand. It was what's been called the child or the brainchild of Arthur von Mehren at Harvard Law School, and tragically the project failed. There was no agreed text, and in the early years of this century, a little bit like a rebound relationship. If you're in a long-term relationship and it breaks up, sometimes one or both partners find a rebound partner. And I think that's a little bit what happened with the choice of court agreements convention, because immediately upon failure of the more ambitious judgments convention, the Hague Conference, with I think the political sense that it had to accomplish something, decided to pursue a much more limited scope of a convention, and it landed upon the Hague Convention on choice of court agreements. Discussions went by international standards, particularly for a multilateral treaty, exceptionally quickly. They basically took less than 2 years when you take account of various pauses and the like in getting started and getting the draft open for signature, and the convention was open for signature in June of 2005. Moving along, and I would suggest that some of the defects in the convention might actually have come from the speed with which it was negotiated, drafted, and open for signature. Today, as Edgardo mentioned in his opening remarks, there are a relatively limited number of contracting states: Mexico, the European Union, the UK, and Singapore, essentially. A few other states have signed, but not ratified. And with that historical background, let's move to what the convention actually says. Before we do that, just a few quotes on the slide from both the explanatory report, but also from what I've called loosely the convention's promoters, most notably those at the Hague Conference on Private International Law, who've been keen to promote, to advertise the convention around the world, comparing it to, as you can see from the various excerpts on the slide, invariably to the New York Convention, recognizing or confirming its aspirations to be a truly global convention. It's open for signature by any state, and the aspiration is, like the New York Convention, to be truly global, to have 170, 180, however many contracting parties can be obtained. Let's see whether that promotion is well considered, though, and as I promised, a whirlwind tour through the structure and provisions of the convention. The scope of the convention, it's limited to international cases. I won't take you through the details of what precisely that means, but it's directed at cross-border choice of forum agreements and recognition of foreign judgments. There's some nuances to those definitions, but for today's purposes, those are not important. What is important is that the convention is not directed to a little bit like the New York Convention, not directed to purely domestic cases. The convention also applies only to exclusive choice of court agreements, not to what I think more in common law than civil law jurisdictions, but that in common law jurisdictions are referred to either as submission agreements or non-exclusive choice of court agreements. Only agreements that provide exclusively for the resolution of a dispute in a particular national court are subject to the convention. There is a deeming provision in Article 3 of the convention that treats all choice of court agreements, unless explicitly provided to the contrary, as exclusive choice of court agreements. That's a significant change from at least the number of common law jurisdictions approach, and it's the approach of the convention. Like many other Hague Conference conventions, this is confined to civil or commercial matters, not defined, but also not terribly controversial as to what that definition is. A little unusually, a very large number, I won't take you through all the details, but a very large number of exclusions, which when you add them up, makes the convention to some extent look like Swiss cheese. The number of exceptions as compared to what's covered it may be a little imbalanced. In that respect, the convention, I think, differs to some extent from the New York Convention, although, of course, the New York Convention also is limited to commercial matters and has a non-arbitrability exception, but not a lengthy list that includes such things as validity and infringement of intellectual property rights, immovable property, and the like. Moving along to the substantive terms of the convention, it, like the New York Convention, has two basic components. One component dealing with choice of court agreements, jurisdiction, and one component dealing with the recognition of judgments. And let's start with the first of those two major parts. The basic rule, a little unsurprisingly, is as stated in Article 5, which you can see on the slide, that a court selected in a choice of court clause that's subject to the convention has jurisdiction to decide disputes that have been submitted to it, unless that choice of court clause is null and void under the law of that state, the state of the chosen court. Importantly, Article 5 contains both a positive grant of jurisdiction that is coterminous with, extends just as far as a valid choice of court agreement, and also a choice of law provision that selects the law of the chosen state to govern the validity of the choice of court agreement. Null and void isn't defined in the convention. It parallels the precisely same formula in the New York Convention, although the explanatory report also goes on to say that the concept applies only to grounds for substantive invalidity. The explanatory report indicates that includes questions of formation, existence, as well as other questions of validity. The explanatory report also, with respect to the choice of law rule, expresses the view that in choosing the law, selecting the law of the chosen state in the choice of law agreement, one looks to that state's conflict of laws rules as well. So this is a little bit different from most private international law approaches, where a choice of law provision does not put you into a renvoi circumstance where you look to the conflicts rules of the chosen law. The convention, a little bit differently here, does present that issue, and therefore the certainty or predictability that might come for the choice of law is at least arguably diluted, at least in some cases where one would need to perform a new choice of law analysis. I think the expectation of the convention's drafters was, however, that it would be the substantive law of the chosen state's legal regime that would apply to determine the existence and validity of a choice of court agreement. Moving along, Article 5 also provides not just that the chosen court can exercise jurisdiction, but that it must do so. It cannot decline jurisdiction, and you can see that in Article 5, subparagraph 2. Moving along and trying to pick up the pace just a little bit, because I suspect some of you are already familiar with the details here. Article 6 of the convention then does essentially for other courts what Article 5 does for the chosen states courts, namely provide that those other courts other than the chosen state, may not resolve the dispute, subject to a variety of exceptions, most importantly, that the choice of court agreement is null and void under the law of the chosen court's state. There are a variety of other relatively unimportant exceptions to the basic obligation of other states than the chosen court not to hear the dispute, but the basic rule is that if you have a choice of court agreement and it's not null and void, the dispute will be resolved in and must be resolved in the courts of the chosen state, and other states must dismiss the action in preference to that of the courts of the chosen state. Moving along now to the second major component that the convention provides for, recognition and enforcement of judgments, and this is highly important. It parallels Articles 3, to some extent 4, and most importantly 5 of the New York Convention, and it establishes, unsurprisingly, the general rule that a judgment rendered by the chosen court, the court chosen by an exclusive choice of court agreement, shall be recognized and enforced, subject to a limited number of specified exceptions. Let's move along and see what those exceptions are. And you can see them on this slide, and in a moment, the next slide. Most importantly, and I'm going to come back to this in my subsequent assessment of these provisions, Article 9 provides that a choice of court agreement, that is a judgment resulting from a choice of court agreement, need not be recognized if the choice of court agreement was null and void, a parallel in a sense to Article 5.1a of the New York Convention. But, and this is critically important, the exception does not apply if the chosen court has already determined that the agreement is valid, that it's not null and void. It's a fundamental difference from the New York Convention, Article 5.1a. It's a fundamental difference from almost all countries' private international law regimes. And it is something we're going to come back and talk about in a moment. 9b is, in a sense, a subset of 9a, a question of lack of capacity. Doesn't come up frequently in commercial cases in any event. It parallels one subpart of Article 5.1a of the New York Convention. Article 9c, lack of notice to the defendant or notice that was incompatible with fundamental principles of the requested state. A more limited version, if I can put it that way, of Article 5.1b of the New York Convention. Article 9d, non-recognition is permitted if the judgment was obtained by fraud in connection with a matter of procedure. Not really a parallel to any provision in the New York Convention. And the explanatory report narrows what is already a relatively narrow provision by specifying that fraud requires deliberate dishonesty or wrongdoing. Moving along through the remaining exceptions, the public policy exception, which parallels Article 5.2b of the New York Convention, albeit in a more narrow fashion. Recognition and enforcement would be manifestly incompatible with the public policy of the requested state, including situations where the specific proceedings leading to the judgment were incompatible with fundamental principles of procedural fairness of that state. Note the focus there on the specific proceedings, a very narrow focus with respect to so-called procedural public policy on the particular proceedings that were in question. And finally, two provisions that we don't need to dwell on regarding inconsistent judgments. With that background, let's move on and obsess the convention. As I mentioned previously, the promoters of the convention, the Hague Conference, others, have been quite enthusiastic, I think it's fair to say, about the convention. They've described it. You can see various of the quotes on the current slide as the next best thing, in a sense, to frozen pizza. That the convention really will solve many problems in international trade and commerce. It will be one of the most important conventions, private international law conventions of the 21st century. It will be the counterpart to the New York Convention for choice of court agreements. Let's see if that enthusiasm is warranted. And I think you already, moving on to the next slide, know what I think about that. Let's start with a more general view of this basic topic before we return to some of the specific provisions in the Choice of Court Agreement Convention. Let's start with the basic question: is it wise, is it appropriate to treat choice of court agreements and national court judgments in the way that the New York Convention, in the way the UNCITRAL model law and international commercial arbitration, in the way that most countries around the world treat international arbitration agreements and awards? And some might initially think, of course it's appropriate. If you can trust a private arbitrator, why can't you trust a state court? If you're going to enforce a private arbitral award, why shouldn't you recognize a national court judgment? I would invite you to think more rigorously and carefully about that proposition, because in a sense, that is the premise. That's the basic premise of the Choice of Court Agreement Convention. It makes sense to replicate the New York Convention for choice of court agreements and the resulting national court judgments. And I would invite you to conclude that, in fact, it doesn't make sense, particularly in the world that we live in today. That, in fact, there are good reasons to treat arbitration agreements and awards the way that we do, and those reasons do not apply to choice of court agreements and national court judgments, which is why for the last century, since the Geneva Protocol and the Geneva Convention started the treatment of international arbitration agreements, we haven't adopted the same approach. No countries have adopted the same approach for international forum selection, choice of court agreements, and the resulting judgments. And let's move to the next slide to begin to explain why. First, think how international arbitration, although you occasionally hear references to the autonomous character of international arbitration and to the independence of the arbitral process, think how international arbitration has built into it, constitutionally, structurally, a number of critically important safeguards for both consent and the regularity and integrity of the adjudicative process. Think how international arbitration results in the beginning from the consent of the parties to arbitrate, which is like a forum selection agreement, but how then thereafter the parties' consent remains central to and fundamental to the arbitral process at every step, including selection of the arbitrators, selection of an arbitral institution who then independently oversees the arbitral process, selection of the arbitral procedures where the parties can, through their agreement, either before or after the arbitration commences, govern the procedures in the arbitration. All of that makes the arbitral process subject to the party's will throughout its duration, and importantly, gives the parties the ability to check potential unfairness, potential lack of integrity in the arbitral process. Think also how the international arbitral process involves fundamentally both arbitral institutions on the one hand and national courts in a limited role on the other hand. In both cases, acting as a safeguard with respect to the parties' consent and to the fairness of the arbitral process, a safeguard that exists outside the authority of the arbitral tribunal. And by that, I mean, the arbitral institution acts as a check on who the arbitrators are. It acts as a check on challenges to the arbitrators and is responsible in many cases for those decisions. It acts as a check on the fairness of the arbitral process. And in the event that it doesn't do those jobs properly, national courts have authority to do that then in both annulment actions and, as we're going to see, in recognition actions under Article 5 of the New York Convention. And the reason I explain all that is that one of the reasons that the New York Convention treats international arbitration agreements and arbitral awards the way that it does is because the arbitral system has, notwithstanding, in my view, incorrect claims occasionally of the autonomy of the arbitral process, a number of very important inherent checks and balances within it and outside it, in which both arbitral institutions and national courts in the arbitral seat and elsewhere ensure that there was in fact consent and in fact that there was a fair, regular, and honest adjudicative process. In contrast, and I'll try to take these next slides quickly because I really don't think there's much dispute about this. In contrast, choice of court agreements and national court judgments lack those checks, particularly under the Hague Choice of Court Agreements Convention. I don't want to embarrass national court judges if we have any here today. I don't want to comment negatively on judges in any particular country. But I think we all know, particularly those of us who've litigated in global disputes, that the level of corruption in the public sector around the world, but in particular in national court systems is deeply disappointing, is highly concerning. A number of nonpartisan, independent, non-governmental organizations have studied this topic for literally decades now. Transparency International releases an annual global corruption barometer. It's quite unfortunate that one actually has to measure something like this, but its conclusions over the years, if you go through and read Transparency International's findings, are truly shocking. 1 in 4 people around the world say that in the past 12 months, they have paid a bribe, put aside being asked to pay, solicited to pay a bribe, actually paid a bribe in the public sector. Similar statistics specifically for judicial proceedings. If we move to the next slide, we can see other studies by Transparency International in different parts of the world. Worldwide, 30% of all participants, responders, reporting corruption with judges and magistrates in jurisdictions around the world, particular regions experiencing especially high levels of corruption. Moving to the next slide. This slide, just for your own reading benefit, summarizes a variety of those conclusions. Next slide. Linked to a lack of integrity, linked to the risk of judicial corruption, is also a lack of judicial independence. It's something where, unfortunately, again, experience over the last decade has not been positive, has not been seeing more independent judiciaries around the world, but on the contrary, moving in exactly the opposite direction. If you look at the rankings here with respect to judicial independence, some of the findings are truly shocking. More than half of all the jurisdictions studied by the World Economic Forum concluded that there was a below average incidence of judicial independence. I think if one sees the control that in many states are exercised over the judiciary. One entirely understands those conclusions. Next slide, please. Even in jurisdictions which make real efforts to address issues of judicial independence, the findings are somewhat alarming. You can see here a study of judicial independence by the European Commission itself, the Eurobarometer survey, which shows a pretty staggering lack of judicial independence in a number of jurisdictions. Next slide, please. And this slide summarizes the findings of both the EU, but also a number of other non-governmental authorities. The Heritage Foundation, for example, has also done careful studies on the lack of judicial independence around the world. Relatedly, and of some concern, on the next slide is a basic lack of competence, which the EU has rightly associated with the lack of judicial independence. I think anybody who's litigated internationally can attest to, particularly at trial court levels, first instance levels in many jurisdictions around the world, the ability of judges well to handle and to decide complicated international commercial cases is quite lacking. One of the benefits, of course, of arbitration is that the parties are able to select arbitrators, decision makers who do in fact have the requisite competence, specialized in the field, familiar with the region and the like. And in contrast, parties lack the ability to do that in national courts. But where do all these observations lead us? Next slide hopefully helps us answer that question. As I mentioned, there's no similar findings with respect to arbitral tribunals. I wouldn't say that there's never been a case of corruption in international arbitration. There have no doubt been instances, but there is nothing remotely like what one sees in national courts, precisely because of the roles of the parties on the one hand and arbitral institutions and also national courts acting in a very limited external role that one sees with respect to the Transparency and International, Heritage Foundation, and other statistics I've described. Next slide, please. And again, I began by saying this, the New York Convention, the UNCITRAL model law, provide within it a framework to reduce the risks that exist with respect to corruption that can affect determinations of consent, that can affect the fairness of the adjudicative process. And those checks arise both because of the parties' involvement in the arbitral process, both parties able to monitor and take appropriate steps as a consequence, the arbitral institution's role, and then the role of national courts, both at an annulment and, importantly, recognition stage. Moving on. That sort of brings me to a conclusion with respect to my general observation about the appropriateness, the wisdom of using the New York Convention as a model, an aspirational objective for the Choice of Courts Convention. The reasons that it makes sense to give effect the way the convention does, the New York Convention does, to arbitration agreements and arbitral awards don't exist, and instead are contradicted in the context of national court judgments. Where you have the incidences of corruption, the lack of judicial independence, the lack of basic competence in the national court process, the reasons you recognize arbitral awards don't apply, and you ought not to be trying to replicate for choice of court agreements what you do for arbitration agreements. You ought not be replicating for national court judgments what you do for arbitral awards, because they're different creatures. Importantly, even if one and one point that I'm going to come before I move on, one point that I'll come back to subsequently. This is not just my personal assessment in that sense, and I hope yours. It's also the way that the Hague Conference has always treated these issues in the past, as we're going to see in a subsequent slide. Previous Hague Conference agreements, treaties for recognition of judgments always included provisions for bilateral relations, did not adopt the New York Convention's approach to a global constitution. Rather, under the previous Hague Conference judgments recognition convention, states decided what other states they would enter into the treaty relations with. The basic concept was the convention would provide a framework for bilateral relations, so you could choose to recognize judgments from particular states without obligating yourself to recognize judgments or form selection provisions with respect to other states. And I'd suggest that the hasty departure from that basic rule was unwise. Given what I've said, though, I think it's important now to turn to the specific provisions of the Hague Conference, the Hague Convention, and consider how, notwithstanding the concerns I've raised about national court proceedings, the choice of court agreement convention diluted, rather than, as one might expect, elevated the protections for both consent on the one hand and procedural integrity and fairness on the other hand. Given what I said about national courts, you might have thought, well, we should have then greater protections to ensure that the parties really did consent to a particular forum. We should have greater safeguards for procedural integrity. And in fact, unfortunately, the choice of courts agreement convention does exactly the opposite. Let's start with consent and then separately look at and party autonomy, and then separately look at the question of procedural integrity. The arbitral process has in it multiple guarantees that the parties really did consent to arbitrate. Those guarantees exist firstly at the level of an arbitral institution, which can perform as many institutions do, a prima facie review of whether or not there's a valid arbitration agreement. Then at the level of the arbitral tribunal, which has the competence to consider challenges to its own jurisdiction. Also, and simultaneously, sometimes, at the level of the courts of the arbitral seat or another jurisdiction under Article 2 of the New York Convention, whereby parties will only be referred to arbitration if the court in which a litigation is commenced concludes that the arbitration agreement is null and void. Critically, there's also a check in the annulment procedure in the arbitral seat, where a national court outside the arbitral process will consider whether there was a valid agreement to arbitrate. And then finally, in the recognition forum under Articles 5.1a and 5.1c of the New York Convention, where an award may be denied recognition if the recognition court, making its own assessment of the existence and validity of the arbitration agreement, concludes that there was a valid arbitration agreement. Multiple checks to ensure that parties really did consent to arbitrate. In contrast, as I described previously, the Hague Convention is fundamentally different. Under Article 9, if the chosen court itself decides that there's a valid choice of court agreement, that decision is binding on the recognition court. That departs radically from Article 5.1a of the New York Convention, from Article 36 of the UNCITRAL model law, and from private international law regimes in almost all jurisdictions around the world. Relatedly, the Hague Convention also has no parallel to Article 5.1c, which concerns excessive authority, or put differently, the scope of the arbitration agreement. There's no parallel provision with respect to the scope of a choice of court agreement. And thus, with respect to the national court judgments, about which we ought to have the concerns that I've outlined, the Hague Convention takes down one of the most important checks to ensure that the chosen court really did properly find that there was consent. It takes any check at all down if the chosen court concludes that there was a forum selection clause selecting, a valid forum selection clause selecting that court. Next slide, please. And much the same thing occurs with respect to issues of procedural fairness, procedural integrity. New York Convention contains very significant protections there. Article 5.1b provides for non-recognition of an award if the recognition court concludes that a party was either denied notice or wasn't provided an adequate opportunity to present its case, an opportunity to be heard. National arbitration legislation, the Untitled law, and Article 36(1)(a)(2) provides for similar guarantees with respect to procedural fairness. At the same time, Article 5.1d imposes an additional check on procedural regularity to ensure that the arbitral procedure was conducted in accordance with the parties' agreement. In contrast, the Hague Convention significantly dilutes the protections for procedural integrity. You'll recall my references to Article 9D, which allows for non-recognition where a judgment was obtained by fraud in connection with a matter of procedure. So I guess you can commit fraud with respect to matters of substance, but not matters of procedure, and still have an award, a judgment recognized. But more importantly, fraud, of course, ought to be a ground for non-recognition, but it's not the only ground with respect to procedural regularity. Negligence, inadvertence, incompetence, or non-fraudulent errors can produce a fundamentally unfair procedure, just as fraud can. Article 9D doesn't cover any of those situations. Next slide. And it's important that the other provisions of Article 9 also don't cover the kind of procedural unfairness that I think ought truly to concern us in the context of national court proceedings. A judgment under Article 9E can be denied recognition if it's manifestly incompatible with the public policy of the requested state. Note the reliance on public policy here, or where proceedings were incompatible with fundamental, where specific proceedings were incompatible with fundamental principles of procedural fairness. Now, these two provisions, I would suggest, do not replicate and instead materially dilute what Articles 5.1b and 5.1d of the New York Convention do. They relegate procedural fairness to a matter of public policy, which famously has been described both as a horse that nobody quite knows where you will be taken, or alternatively, exceptionally narrow and a true exception. Treating procedural integrity and fairness as a subset of public policy, I would suggest, introduces both unpredictability, but also undue narrowness to the guarantees for procedural fairness that ought to apply, particularly given what we've seen about the incidences of judicial corruption and lack of judicial independence. In that regard, it's also important that Article 9E limits the grounds for non-recognition to cases where the specific proceedings leading to the judgment were procedurally defective as a matter of public policy. Why do I emphasize the specific proceedings? I emphasize it because, as a practical matter, the task of demonstrating that there was corruption or a lack of independence in a specific proceeding is extraordinarily difficult. people who bribe judges go to great lengths to make sure you can't find out about it, just like judges do if they are the kind of people that take bribes. Requiring a showing with respect to the specific proceedings in question is entirely, in my view, unrealistic. What it means is one can't, in resisting a recognition of a judgment under Article 9E, point to the general corruption of a legal system, to the general lack of judicial independence. And I would suggest that is a fundamental failing in Article 9E and the Choice of Court Agreements Convention itself. Moving along to the next slide. And this is a point that I made previously. It's in part precisely for these reasons that previous Hague conventions have established what I previously described as a framework for bilateral relations, not a global convention. And you can see examples from the 1971 Hague Convention on the recognition and enforcement of foreign judgments, and the more recent 2019 Hague Convention of the same name, Articles 21 and 29, providing for bilateral relations, not a global treaty like the New York Convention. Next slide, please. And so for all those reasons, I would invite you to conclude with me that the New York Convention does not provide a suitable model for choice of court agreements or for national court judgments, and that it is particularly true that the Choice of Court Agreements Convention dilution of protections for party autonomy on the one hand and procedural fairness on the other hand mark a fairly radical divergence from the New York Convention, when in fact any divergence should be in the opposite direction, in the direction of enhancing the guarantees for true consent on the one hand and fairness, integrity of the adjudicative process on the other hand. Now, I have a number of slides, if we move to the next slide, which I think I'm not going to go through, but I'll summarize them very quickly so that we have time for questions. The slides basically report, if I can put it that way, on the debate that has arisen on the Kluwer arbitration blog. I'd encourage you all, if you're interested, to read the various contributions on the blog yourselves. Two of the promoters of the Hague Convention, unsurprisingly, took some issue with my conclusions about their convention. João Ribeiro, first secretary at the Hague Conference, Trevor Hartley, one of the co-authors of the explanatory report to the convention, both made a number of responses. Let me only highlight, for today's purposes, a couple of those responses, because I think they are illuminating. You can, from the slides, see what the other responses were. The first, Trevor Hartley, in my view, a little unsurprisingly, said that, oh, the New York Convention wasn't really the model for the Hague Convention. Instead, the model was the Brussels Convention, later Brussels Regulation. To which I said two things. First, that unfortunately isn't accurate. And I've cited both in the slides that you've seen and otherwise a very large number of comments, including in Professor Hartley's explanatory report, in which it was the New York Convention that was described as both the Hague Convention's model and its aspiration. And certainly the Hague Convention's other promoters have very frequently drawn exactly the same parallel. Perhaps more importantly, though, as a substantive matter, it's just not accurate to say that the Brussels regulation was a model for the Hague Convention and the New York Convention wasn't. Think about the question structurally, so as a matter of substance and architecture. The New York Convention deals with two things: international arbitration agreements and arbitral awards. It doesn't deal with other types of jurisdiction. It doesn't deal with other types of judgments. It's a global convention open to everybody. The Brussels regulation is almost the opposite. The Brussels regulation deals with all types of jurisdiction, only one small part of which is choice of court agreements. And it deals with all kinds of judgments, not just judgments resulting from choice of court agreements. It is a purely regional regulation. The name is illuminating, not a global convention, the way the New York Convention is. Which one of those two things does the Hague Convention look more like? I think you all know the answer. It's a global convention that deals only with choice of court agreements and resulting judgments. It is about as far from the Brussels regulation as an orange is from an elephant. But it is, in my view, quite illuminating that Professor Hartley would look to the Brussels regulation as justification for the Hague Convention. Because if you think about it a little more deeply, analogizing the Hague Convention to the Brussels regulation reveals exactly why we oughtn't to have a global convention for choice of court agreements. The Brussels regulation is premised on a common political system with a common law, European Union law, with a common apex court, the European Court of Justice, and a common legislative authority that can give effect to EU law. It's based on a regional political integration project and has aspirations for a national identity. That is utterly different than a global convention that has 170 or 190 nation states without any common apex court or legislature, and with radically different political, legal, cultural, linguistic regimes. Trying to analogize the Hague Convention, which aspires, like the New York Convention, to be a global convention, to the Brussels regulation, reveals, in my view, exactly why you can't make that analogy, the analogy between the New York Convention and the Hague Convention. The only other point that I would like to make is that João Ribeiro, the first secretary, a good friend, argued that it's important to have international treaties. It's important to have international agreements. And I would agree with that. Treaties play a very important role in international commerce, international trade and investment. Critically though, bad treaties, bad international law isn't a step forward, it's a step backwards. And I would suggest that the Hague Convention isn't good international law, isn't a good treaty. It will lead to ultimately corrupt judgments from corrupt courts being imposed on innocent parties. And why should countries like Mexico, countries like Singapore, open themselves up and, most importantly, open up their businesses, their people, their citizens to that sort of denial of justice? At the end of the day, the Hague Convention creates significant risks of denials of justice and requires states around the world to give effect to those denials of justice. That doesn't advance, in my submission. It detracts from the rule of law and will ultimately inhibit international trade and commerce. I've gone, I think, a fair bit over my allotted time, but hopefully there's still a good time left for questions.
Thank you, Gary. This has been magnificent. We do not often have the opportunity to listen to someone explaining a topic with such a clarity. But I think this presentation is particularly important because it intends to change what is international law today, or what aims to be international law today, because it believes it shouldn't go towards that direction. And that's specifically the case of your view about the Hague Convention on choice of court agreements. So thank you very much, Gary. We have a few questions. Let me see. Yeah. Hold on a bit. Right. Sorry. I think I have them in the chat then. One interesting question here is the following. One of the participants asked whether the appeal system that exists in judicial systems help to alleviate corruption, lack of independence, and incompetence, or does it magnify the problem that you have spotted out?
That's a great question. It's an astute question as well. In a funny way, it's also an astute answer, I think. Yes, to some extent, the appeals process can address all of the various criticisms that I and I think much more importantly others have made about judicial corruption, lack of independence, lack of competence globally. If one had a well-functioning appellate system that could, in a reasonable time frame, without corruption, without lack of independence, and with suitable competence, correct the errors of trial courts, it would address, to an extent, the concerns that I've raised. I say only to an extent because obviously the process of having to litigate in corrupt first instance courts and uncertainties and litigation costs of an appellate procedure themselves are non-trivial problems. I would suggest significant problems. But a well-functioning appellate mechanism would, I think, mitigate some of the risks that I've described. The question, though, is quite astute, if I can say that, because it also highlights the possibility that the appellate process won't make things better, but will make things worse. Just as people can pay trial court judges, they can pay higher instance judges, and there's certainly instances of that around the world. Equally, perhaps more importantly, lack of independence may increase as opposed to decreasing as one moves higher up in at least some judicial systems. Politicians, national governments that are keen to use a judicial system for their own purposes naturally focus on where the largest payoff is, and inevitably that's higher courts. And therefore, I think like the questioner, I would say that although taking into account appellate mechanisms is important, it doesn't fundamentally change any of the criticisms that I've made. And in a sense, I think it points towards the wisdom of the Hague Conference in the 1971 Convention for the Recognition of Foreign Judgments and the 2019 comparable approach, whereby states assessed one another's first instance and also appellate judicial mechanisms in deciding whether or not they wanted to recognize one another's judgments. It requires a more tailored approach on a state-by-state basis.
Thank you. There is a related question to that issue of corruption you have identified. One of the participants asked whether the same risk exists for arbitration because arbitral awards should eventually be recognized by judicial courts.
Yeah, that's a good question, and it highlights a point that I tried to address in some detail during my remarks. Let me start first by saying, just like judges can be bribed, arbitrators can be bribed. Arbitrators are people; they're bad people and they're good people. There's no rule that all arbitrators would be free of corruption, or for that matter, incompetence or lack of independence. However, and importantly, I tried to identify a number of structural, systemic aspects of the arbitral process that make the likelihood of both corruption and lack of independence much, much less likely. Those attributes which I identified included the parties' role in selecting the arbitrators and, importantly, their rights to challenge arbitrators precisely for a lack of independence and impartiality, with an arbitral institution in almost all international commercial cases independently resolving those kinds of challenges and also making the initial appointment. That doesn't, let me emphasize, that doesn't guarantee that there won't be corruption, but I would suggest that it reduces the likelihood materially. National courts then, outside the arbitral process, performing a very limited role, scrutinize the award and the arbitrator's independence and impartiality, and in some cases, for example, under the UNCITRAL model law, can also remove arbitrators during the arbitral process precisely for a lack of independence and impartiality. Now, one might say, well, why do you think national courts can do that, but they can't resolve the case on the merits? I think, and that is a fair question, but I think national courts performing a very limited role of external scrutiny on the arbitral process is a good thing, even if one has doubts about the integrity of national courts to resolve the underlying dispute. It is an external check in a very limited scope of responsibility, which is much more subject to external scrutiny. And thus, I think that these external checks provide another reason that corruption, lack of independence are much less likely in the arbitral process. And then finally, there's that old English expression, the proof of the pudding is in the eating. Arbitration has been flourishing, growing more popular each year, not just since 1958 and the signing of the opening for signature of the New York Convention, but from before that. There have been some instances of corrupt arbitrators, but the number is truly exceptional. There have been a few cases of sham arbitrations where ingenious and unscrupulous entrepreneurs create a fake arbitral institution. But importantly, almost all those instances have been caught. And there's a very interesting case proceeding at the moment in the United States, I think elsewhere, where an award has been denied recognition. An Egyptian award has been denied recognition on the basis that it was a sham arbitration created unscrupulously by, as I said, ingenious entrepreneurs. And thus, I think the question is good. because exactly the reason that you have the safeguards for consent and procedural regularity in the New York Convention recognizes the possibility of corruption, but the arbitral process is structured in a manner, as experience shows, that corruption is vastly less likely than in national court proceedings.
Thank you, Gary. One of the participants points out to the fact that the convention allows choice of neutral forums. Do you have any particular view on that? Can we assume that you have no a negative opinion against this? And I think this is an interesting question.
Yeah, no, it's a good question, and I don't wish my remarks to indicate that you can't have a good choice of court agreement and a good national court judgment resulting from that agreement. Parties can select a neutral forum, which does have independence, which isn't plagued by corruption, which is highly competent in a particular field. You think of some jurisdictions that parties use, for example, for insurance transactions or lending transactions. And the convention clearly is appropriate with respect to those kinds of choices. The problem is, as I said previously, the convention is a global convention that applies to all countries, to choice of court agreements for all jurisdictions, neutral, non-neutral, corrupt, non-corrupt. And it is by failing to provide adequate safeguards in those circumstances that, in my view, the convention is a step backwards, not a step forward.
Yes, thank you. Well, I think we have reached the end of this webinar. Thank you so much, Professor. Thank you to Canaco Arbitration, which is the National Chamber of Commerce in Mexico. I think this has been a very interesting talk, presentation. And so we invite you to stay tuned with the events of Canaco, and we thank Professor Gary Bourne for his time and elucidating all that goes around this topic.
Thank you, Edgardo, and thank you, Andrea. And of course, thanks to all the participants who had the patience to bear with me. Thank you again.
Thank you.
Thank you. Bye.